Good morning, ma'am. You're Louisa Magruder.
Go on.
And we're here in cause number 1625158. We were previously here some time ago. Ms. Magruder is on probation. There's a motion to adjudicate or revoke her unadjudicated probation that was filed. There were pleas of not true that were entered, and this was reset for a sentencing hearing today. I have the updated pre-sentence report. It's my understanding, however, that you guys have now reached an agreement and that Ms. Magruder intends to change her pleas in that motion. Is that correct?
That's
All right. Will she waive the formal reading of the motion?
right. Yeah, we'll wait.
So, Ms. Magruder, we already went through this motion, but because there's going to be a change of plea to some of those allegations, I'm going to go back through it with you, okay? So, I have a motion to revoke your unadjudicated probation. It shows you were placed on probation January 29th of 2018 for the second-degree felony offense of sexual assault of a child, and that was a 10-year deferred probation. Is that correct?
Yes, ma'am.
It alleges that you violated your probation. Count one alleges that you failed to report as directed to the probation department May 23rd and June 2nd of 2025. And is that true or not true?
True.
Count two alleges that you failed to work faithfully at suitable employment and provide verification of that. And is that true or not true? Count three alleges that you did not submit to alcohol or drug screening June 2nd, May 28th, and May 19th of 2025. And is that true or not true? I'm sorry.
True.
Thank you. Count four alleges you're behind in your court assessed fees. Is that true or not true?
True.
And then count five alleges that you did not enter and successfully complete the Jefferson County Drug Intervention Program, the JCDI program. Is that true or not true?
True.
All right. Did you enter your pleas of true now to counts 1 through 5 freely and voluntarily?
Yes, ma'am.
And because they're actually true.
Yes, ma'am.
I have here on the tablet some documents that have your signature on them with your attorneys that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Bynum?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And do you understand if I follow the agreement that you've made with the district attorney that you'll be waiving or giving up any right to appeal?
Yes, ma'am.
State tenders number 1.
No objection.
It's admitted. Is there any evidence Ms. Magruder's not competent?
No.
All right, Ms. Magruder, then at this time, I'm going to find that you entered your pleas of true to counts 1 through 5 freely and voluntarily. Find those counts true. Find sufficient evidence at this time to find you guilty, and at this time find you guilty of sexual assault of a child. Sentence you in accordance with your agreement to a term of 9 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm going to hand you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. Also have handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. If you have any questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Bynum. And we went over way back when you first got this probation, also the sex offender registration. You've already signed that and understand that that's part of this case as well.
Yes.
Okay. Good luck to you, ma'am. Thank you all for working it out. Thank you for being here, Ms. Becker.
It's just brief. It's not.
Okay.
I said, I wrote it 10/5/25. I said, I want to first start off by saying I thank you for giving me a chance and seeing in me what I can't say myself. I remember what you told me the last time I came to court, and my mind or heart isn't set on going home today. But the Lord just placed me in my heart to tell you thank you for being you. I will do my best to make sure I'm being a better person while in jail. I just want to thank you, y'all.
Thank you for that. Good luck to you. I really do wish you the best.
Thank you.
Okay. Good morning. You're Jaden Brantley. And this is cause number 26, DCCR 0422. Mr. Brantley's charged with a first-degree felony offense of aggravated robbery from February 6th of 2026. And what that means, Mr. Brantley, is that if you go to trial and you're found guilty, the range of punishment would be between 5 years and up to 99 years or life in prison. Do you understand?
Yes.
And I have here on the tablet a plea bargain rejection that has your signature on it with Mr. Rojas that shows that the district attorney's office has made an offer if you wanted to enter a plea of guilty for a cap of 25 years in prison, which means you would be leaving your punishment up to me. And as long as I didn't give you more than 25 years, I could give you 25 years, I could give you less. It would all depend on the information that was brought to me at a sentencing hearing. You have every right to reject that offer and have your case set for trial. Let a jury decide. I just want to make sure you understand what the possible consequences are if you go to trial, what your options are if you wanted to plead guilty. Do you understand all of that?
Yeah.
And do you want to reject that offer and have your case set for trial?
That's fine.
All right, we'll get it set for trial. Is there any reason, I know that is Mr. Dickel's case, but is there any reason to believe, is there anything outstanding or why that offer would change?
Looks like the media has been picked up, Judge, as per the offer, nothing to my knowledge.
So I do want to make sure you understand, Mr. Brantley, once I place your case on the trial docket, then it's expected to go to trial. If you change your mind later and want to enter a plea of guilty, it would be to something different than this. Do you understand?
Yes.
All right. And so Mr. Rojas has been appointed to represent you. He's one of the attorneys who handles a lot of cases for me as a court-appointed attorney. With your permission, I can release him and appoint another attorney who could begin preparation for trial a little quicker. Is that okay with you? All right, so Mr. Rojas, you're released. Mr. Brantley, I'll appoint someone today. They should be out to the jail to see you very soon to begin preparation for trial. All right, you can go back with the bailiff.
Yes, ma'am.
Thank you. Jimmy Couch, the Senate.
Jimmy Couch.
Mhm.
Morning, Your Honor.
Good morning, you're Jimmy Couch.
Yes, ma'am.
And this is cause number 26, DCCR 0328. Mr. Couch was previously in court, entered a plea of guilty to the lesser offense of a third-degree felony attempt to commit burglary of a habitation. I've received the pre-sentence report. Have you both had an opportunity to review the report?
We have, Your Honor.
I have, Judge.
Are there any additions? Excuse me, additions or corrections?
No additions or corrections, Judge, just comments whenever the judge would.
Okay. Anything, Ms. Molfino?
Judge, I would just like to clarify for the court that the offer of the attempt to commit was made based on my review of the facts. I think it was more appropriate to the facts of the case that it be an attempt. It was not an attempt, no pun intended, to lessen his culpability or anything of that nature. I just think that fit the facts better and was a more appropriate plea. Ask the court to take notice of the PSI and also for some very brief comments. If the court would find it helpful, I would like to call Mr. Couch's wife, ex-wife, Allison Couch, just to let the court know some things about how strongly she's going to ask the court for safety and the state's going to ask for safety in this case. And I think it would just help give you, if you
That's
feel like you
agreed
need-
though, right?
Safety was not agreed, Judge.
No, ma'am.
Not agreed.
Oh, safety's happening.
Ma'am?
If I give you probation, then safety is going to be a condition of that probation. End of
Yeah, ma'am.
story. So, I mean, either you can, here's the thing, Mr. Couch, conditions of probation
Yes,
are
ma'am.
up to the court, 100%.
Okay.
So even if that had not been part of your agreement, it doesn't invalidate your agreement because I can impose any conditions that I think would be either helpful or necessary to make sure that everybody that's on a probation has the best possible chance of success and that everybody else out there is safe and secure as we can make them. And so if I follow this agreement, it is going to be with safety based on I've got the her statements, and thank you for being here, ma'am. I've got the statements she has here, and I appreciate that she's here in person as well. That means a lot. If there's something that's not in here, we'll take judicial notice of her statements as well as the probation reports statements with regard to substance abuse history and the fact that they believe that he needs substance abuse help, but he does not.
Do I get to make a statement?
Sure.
Your Honor, I don't do drugs. I haven't done drugs since I was a stupid kid, 20 years old. I don't do any drugs whatsoever.
Well, it's not just about drugs, it's about alcohol as well.
And I don't have an alcohol problem, Your Honor. I might drink a beer or two a week. That's it. I don't have any alcohol problem. I mean, I don't understand. I've already lost 6 months of my life, and I have serious lung disease that I have to have another PET scan and another biopsy because Mr. Spot on my lungs are growing. I've coughed up blood 4 times in the last 3 months, been in jail. They will not give me my medications or my lung
Well,
treatment.
maybe you shouldn't have gone and committed this offense.
Your Honor,
Hang on, listen.
I
Okay, just
apologize.
hang on. I understand some medical issues,
Mhm.
but that's not what's going to go into completely any decision that I make. Okay, so just hang on a second.
Okay.
Mr. Rojas,
Judge, I would just point out that at least from his, whatever he self-reported to the probation department, looks like the last time he used any drugs was 2023, and that he tells me that was prescribed from a surgery he had.
Yeah, that's my surgery.
And the last time he used alcohol was August of 2025, and he was out on bond until June of this year. So if that's true, it would tend to show that he didn't have an alcohol problem.
if your witness is willing to come testify under oath, then that would be probably good.
Thank you, Judge. Ms. Couch. Maiden name, Byron.
Okay. Good. Go on.
Don't interrupt.
Okay.
Good morning, ma'am.
Good morning.
If you'll please raise your right hand. Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth?
Yes, I do.
Thank you. Ms. Malfino?
Ms. Couch, would you please state your full legal name for the record, please?
Allison Couch.
And how do you know the defendant, Jimmy Couch?
He's my ex-husband.
Okay. And you tell the court, obviously you are aware that we're here for a sentencing hearing today, correct? And is it correct that you and I have kept in pretty constant communication with respect to this offense? And you filled me in on a lot about the defendant, his history, his substance abuse history that may not be included just with respect to this offense,
That's
correct?
correct.
And do you think it would be helpful to Judge West to hear just a very little bit about that, especially after you've seen how the defendant has acted this morning, which was obviously a concern of all of ours, correct? That he continues to minimize, he distances himself from the severity of his alcoholism or substance abuse problem. Would you think?
He's smiling.
Look at me. You actually do this. Turn around and look at that wall. Go ahead, ma'am.
I'm sorry, Judge. Do you think it would be helpful for the court, from your perspective, to know just a little bit more about Mr. Couch and what you want for him with respect to his trying to get help and why you and I discussed at length this offer and a chance at probation to try to get him the substance abuse help?
The whole point in this and me sticking this through is to get him the help he needs. He's a serious, serious alcoholic. His family knows it. His friends know it. I lived with it. It's terrible. And we love him, but we want him to get well. He hasn't been able to do it on his own. And this is our last resort, is basically what this is.
It's either this or prison, right?
Yes.
And
Or he'll kill somebody while he's out there driving drunk.
do you believe this with everything you know about the defendant?
Everything. I've experienced a lot with Jimmy. It's been a very hard experience. But I do have a lot of love and heart and care for him in my heart to see him through this. I want to see him get help.
And is that in fact why you are asking the court to consider allowing him to serve this probation, but imposing safety, which we have discussed is the most stringent lockdown treatment program with all of the aftercare conditions, et cetera, with a condition that afterwards he have no contact with you? I know we had discussed some things with concern to his sister's concerned she may come there, you're concerned he may come to you. And he's got to learn how to stand on his own 2 feet and not bring his problems back into everyone else's life. You're asking Joe to do that.
Well, we do know that he has nowhere to live. He has nowhere to go. The family knows what's going on. Nobody can take him at this point. But we don't want to see him not have communication with family. We feel like that's part of the healing that he's going to go through. But we do feel that he's going to have to be forced to do this because he has failed on his own prior to this. He didn't complete a rehab he did before. and it's just never, it hasn't stopped.
Thank you. Any questions, Mr. Rojas?
Man, what?
Sorry.
When was that rehab?
It was 2 years ago.
And you guys were still married at that time?
Yes.
And when's the last time you actually saw him take a drink?
Right. Oh, he was drunk when he came to my house and got arrested. Yeah, he's been drinking up until he got arrested.
And that was in January.
Yes.
Pass the witness, Judge.
Right. Thank you very much, ma'am.
Can I turn that?
I'm standing right here.
I'll get,
Any other witnesses?
They are.
No,
All right.
can I call my witness?
No, you have an attorney. Mr. Couch, what you're doing today is giving me more and more concern about whether or not I should even follow this agreement. You are interrupting, you are denying everything. In fact, I already had a mark in this pre-sentence report that you pretty much your version of the offense is not what the version, the official version is, and it's not accepting responsibility. Flat out not accepting responsibility. So if I'm going to go along with this agreement, it is going to be with help, whether you think you need it or not. So at this time, in cause number 26, DCCR 0328, going to find that you entered your plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty, but I'm going to follow the agreement and defer all proceedings and place you on probation for 3 years. You're ordered to pay a $500 fine and to follow all of the rules and conditions of probation. That is going to include entering and successfully completing the safety program. You have, it sounds like, people who love you and care about you and want you to do better. It's going to be up to you to do that. Part of your probation is going to be to have no in-person contact with Allison Couch. If there is at the time through probation that communication is helpful and positive, then I would allow that, but that's going to be through probation and through your family and or Ms. Couch reaching out to them and saying that that's okay. I'm handing you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. I hope you take advantage of this, Mr. Couch.
Ma'am, can I make one more statement, please?
What's that?
She got all my property. She's got all my property, my IDs and everything. I can't even get money out of the bank or anything, but she has all my property. Can I have a week or something to get my truck out of the tow yard and I'm gonna lose my truck?
No, I'm sure it sounds like there's people that will help with that.
There
Talk to
is
Mr.
no
Rojas.
one, Your Honor. There is no one.
Well,
I can't even make a phone
I'm not
call.
going to let you out. All right. You can go back with the bailiff.
How do I do that?
that's just your speaker.
Corbin Rayleigh, Mr. Rojas, is she sentencing?
What starts as a routine sentencing hearing quickly becomes a tense confrontation when Jimmy Couch begins pushing back against the concerns raised about his substance use and behavior. While the court is considering a probation agreement that could give him an opportunity to get treatment instead of going to prison, his repeated interruptions and refusal to acknowledge the seriousness of the issues described in the presentence information begin to concern Judge West. His ex-wife then gives emotional testimony, explaining that the people closest to him believe he needs professional help and that previous attempts at rehabilitation had not worked. The judge makes it clear that probation is not simply a way to avoid consequences. It comes with conditions designed to protect others and give the defendant a genuine chance to change. In the end, Judge West follows the agreement and places Couch on 3 years of probation, including mandatory completion of the treatment program, a $500 fine, and restrictions on contact with his ex-wife. The hearing shows how quickly a defendant's own behavior in court can influence the judge's confidence in a proposed sentence, and how probation can come with strict expectations rather than an easy way out.